Hey everyone, and welcome to this explainer. If you were in Kenya back in May 2026, you absolutely remember the shock at the pump. We're talking about record-breaking fuel price hikes that just sent ripples of economic pain everywhere. Sector strikes, massive public outcry, you name it. But, well, this isn't just about everyday frustration anymore. This economic pain has actually transformed into a massive, high-stakes legal battle. Today, we're zooming in on exactly what is being challenged in court, taking you step by step through the anatomy of a lawsuit that has literally gripped the entire nation. Okay, let's dive into this. Why exactly are Kenya's fuel prices ending up in court? Well, the short answer is that the sheer scale of those price hikes triggered an absolute avalanche of lawsuits from completely different sectors of society. So rather than letting all these parallel cases drag out separately, on July 2nd, 2026, High Court Justice Aburili stepped in and made a really decisive move. She merged all these multiple lawsuits into one massive, consolidated case. The goal here is pretty straightforward. Prevent a bunch of duplicate proceedings, and more importantly, completely avoid the risk of conflicting judicial decisions on something the public cares so deeply about. So, because of that consolidation, we have two distinct petitioners who've essentially been forced to join forces, creating this really united legal front against the Energy and Petroleum Regulatory Authority, or EPRA, along with other state agencies. On one side, you have the Law Society of Kenya, or LSK, and they are aggressively challenging the alleged opacity of the pricing formula and the massive tax burdens placed on consumers. On the other side, matching that exact intensity, is Francis Awino of Mtetezi movement. They are heavily focused on procedural unfairness, consumer rights violations, and some incredibly serious environmental risks. Here is our roadmap for today. First, we'll look at the petitions themselves. Then, Challenge 1, the pricing formula. Challenge 2, the $5 billion fund. Challenge 3, the Sulphur waiver. Next, we'll cover EPR's defense. And finally, the legal timeline. All right, starting with part 1, the petitions, a unified legal front. Let's look at the exact numbers that acted as the catalyst for these legal filings. On May 14, 2026, EPRA announced the new maximum retail prices, and the jump was just staggering. Super Petrol went up by 16 shillings and 65 cents, bringing it to 214.25 in Nairobi. Kerosene stayed unchanged, but look at that middle point. Diesel didn't just increase, it skyrocketed by an unprecedented 46 shillings and 29 cents per liter, hitting a record 242.92. For the petitioners, a shock to the system of this magnitude is completely unreasonable, and they argue it flat-out violates constitutional consumer protections. Let's move on to part 2. Challenge 1, the pricing formula. You can really think of this challenge like citizens demanding to see the itemized receipt for their fuel costs. The petitioners are basically claiming the current system is a total black box. To prove these prices aren't just being artificially inflated, they are demanding EPRA publicly disclose the entire formula. They want it all out in the open. The exact landed fuel costs, a full list of applicable taxes and levies, the exchange rate assumptions being used, the specific profit margins for oil marketers, and the ultimate criteria used to set those final pump prices. They're essentially saying, show us the math. Next up is part 3. Challenge 2, the $5 billion fund. Now, what's really interesting about this is the sheer mind-boggling scale of the money we're talking about here. 5 billion shillings. This all revolves around the Petroleum Development Levy Fund, or PDLF. And the burning question is, where exactly did that 5 billion shillings go? See, this is a fund that was intentionally built to protect consumers, to cushion you from global oil price spikes. But the petitioners allege that roughly 5 billion shillings from this reserve were spent without any adequate disclosure or accountability. Because of this alleged secrecy, they are demanding a complete spending freeze on the PDLF until the government provides a full public breakdown of exactly where those funds went. All right, part 4, Challenge 3, the Sulphur waiver. Now, this is an often overlooked but absolutely critical environmental challenge raised specifically by the Awino petition. On May 1st, a temporary 6-month waiver raised the standard permissible sulfur content in diesel from a safe 10 parts per million all the way up to 50 parts per million. Now, the government justified this by pointing to global supply disruptions, specifically issues in the Strait of Hormuz. But the petitioners are fighting back hard. They argue this relaxed limit creates severe pollution and very real public health risks for Kenyans, and they're demanding the waiver be suspended immediately. Which brings us to part 5, EPRA's defense. The regulator strikes back. Now we have to look impartially at the other side.
because EPRA firmly denies all these allegations of secrecy and unlawful conduct. Listen to how Dr. John Mutwa, EPRA's Director of Economic Regulation, puts it. He says, the regulator operates within the law. The petitions are largely driven by public dissatisfaction with global fuel market trends. So their stance is essentially that they're playing entirely by the rules, and this massive lawsuit is just fueled by everyday economic frustration, not actual legal violation. If we break down EPRA's legal defense, they basically have three main counterpoints. First, they argue they've already met transparency requirements because the 2022 petroleum pricing regulations are publicly accessible. Second, regarding margins and costs, they point to their COSOP study, last updated in October 2024, which handles all that through stakeholder consultation. And third, they claim the petitioners never even filed formal requests under the Access to Information Act before rushing to court. Because of all this, EPRA strongly believes that a structural interdict, or spending freeze on the levy fund, is legally unwarranted. And finally, Part 6, the legal timeline. What happens next? Justice Aburili has laid out a really strict, fast-track timeline for this high-stakes showdown. Here's exactly how the next month of legal maneuvering will unfold. Respondents have 14 days to file their replies. After that, the petitioners get another 14 days to file their supplementary affidavits. And then, at a date to be determined, everyone heads back to court for the highlighting of final submissions. So yeah, the clock is officially ticking. So what does this all mean? Will this case completely rewrite the rules for consumer transparency in Kenya? We are watching a legal battle that goes way beyond just 1 month of fuel prices. The outcome here could either legally validate the current pricing structure, or it could force a historic, massive overhaul of how public funds and fuel costs are managed in the middle of a cost of living crisis. The entire nation is waiting to see what the High Court decides. Thanks so much for joining me for this explainer. Keep questioning, keep exploring, and I'll catch you next time.